Hello, my name is Farhan Fadila, and we are from Group 18. Today, we are going to discuss how judge-made laws have developed in the English legal system under the concept of separation of powers. I will be discussing judge-made laws under the perspectives of the legislature and executive in the United Kingdom.
Hello, my name is Riksha Nair, and I'll be discussing about the case of Kleinwort Benson Limited and Lincoln City Council 1999 and the judgment of Lord Brown Wilkinson. In truth, judges make and change the law. The entirety of common law is judge-made law.
Hello, my name is Yisingja, and adding to Farhan's point, I'll be discussing on the judiciary system and how judge-made laws are accountable.
Hi, my name is Chong Fong. I'll be presenting about the history of the developments of common law.
And I'm Anil Malik Chu, and I'll be presenting the development of judge-made law in specific areas of law, contrasting statute law with entirely judge-made law, civil law.
My name is Rumaisa Sharif Khan. I will now be talking about the different doctrines that led to the development of judge-made law.
Hello, my name is Joe Ginger. I'll be presenting on the advantages as well as the disadvantages of judge-made law.
Kleinwort Benson Limited and Lincoln City Council 1999 is a notable legal case decided by the House of Lords, now the Supreme Court of the United Kingdom, in 1999. The case addressed the concept of unjust enrichment and the circumstances under which a party can seek restitutionary damages. The facts of the case involved Kleinwort Benson, a bank, entering into interest rate swaps with Lincoln City Council. The swaps were based on an erroneous understanding of the law, and when the mistake was realized, Lincoln City Council terminated the contracts. Kleinwort Benson then sought to recover the substantial loss they incurred due to the early termination of the swaps. The central issue before the court was whether Kleinwort Benson was entitled to restitutionary damages for Lincoln City Council's unjust enrichment. In simpler terms, the question is whether the council had received the benefit unjustly at the bank's expense, and if so, whether the bank was entitled to be compensated for the benefit. The House of Lords held that Kleinwort Benson was indeed entitled to restitutionary damages. Lord Gough, delivering the leading judgment, emphasized that unjust enrichment occurs when one party receives a benefit at the expense of another party in circumstances that are unjust or inequitable. He further explained that restitutionary damages can be awarded to reverse the unjust enrichment and restore the parties to their original positions. The decision in Kleinwort Benson clarified and expanded the principles of unjust enrichment in English law. It established that a claim for restitutionary damages can be made when there is no underlying legal obligation but an unjust enrichment has occurred. The case has since been cited as a significant authority in subsequent legal proceedings involving unjust enrichment and the recovery of restitutionary damages in the United Kingdom. The potential to establish new legal principles and set a precedent for future cases. Through their legal reasoning and analysis, the law lords in the House of Lords examined existing case law, relevant legal principles, and equitable considerations to arrive at their decision. By doing so, they shaped the common law by clarifying the concept of unjust enrichment and expanding the scope of restitutionary damages. Reasoning and differing opinions play a crucial role in shaping legal principles, even when their views do not prevail in a particular case. Lord Brown Wilkinson stated, "The main effect of your Lordship's decision in the present case is to abolish the rule that money paid under a mistake of law cannot be recovered, which rule was based on the artificial assumption that a man is presumed to know the law. It would be unfortunate to introduce into the amended law a new artificially, viz. That a man is making a mistake at the date of payment, when he acts on the basis of the law as it is then established. He was not mistaken at the date of payment. He paid on the basis that the then binding Court of Appeal decision stated the law, which it did. The fact that the law was later retrospectively hanged cannot alter retrospectively the state of the payer's mind at the time of payment." Lord Brown Wilkinson accepted that judges make law and may later change the law. Put somewhat differently, Lord Brown Wilkinson also rejected the myth that the common law pre-exists to be revealed by judges. Had this myth been true, then the law could not be said to change and adapt, nor could it be said that judgments operate retroactively to change the law. Had the myth been true, then it would also have followed that the parties would indeed have been mistaken in their understanding of the existing law at the time when they entered into the swaps transaction, but the myth was not true. Therefore, in his view, it was possible that the parties to the swap transactions had made no mistake at the time they entered into the transaction.
Thank you, Subiksha, for your presentation. My name is Farhan Fadila, and I'm going to discuss the concept of strict separation of powers that established that judges are merely declarers of the law. The doctrine of the separation of powers suggests that the principal institutions of state, such as the executive, the legislature, and judiciary, should be divided in function to safeguard liberties and guard against tyranny. According to a strict interpretation of the separation of powers, none of the three branches may exercise the power of the other, nor should any person be a member of any of the two of the branches. Instead, the independent action of the separate institutions should create a system of checks and balances between them. However, many countries opt for a compromise instead of aiming for a strict separation of powers. In the UK, the powers of Parliament, government, and courts are closely intertwined. In fact, the executive and legislature are seen as a close union, a nearly complete fusion of the executive and the legislative powers, which Walter Bagehot viewed as the efficient secret of the English Constitution. Presently, a judge's role is not to make law, but to uphold the laws which are made by the Parliament. Each law that is made by the Parliament must be closely defined and applied by judges in accordance with the cases. Lord Muscle, from the judgment of Crown against Home Secretary ex parte Fire Brigades Union, 1995, said that Parliament has a legally unchallengeable right to make whatever law it thinks right. The executive carries on the administration of the country in accordance with the powers conferred on it by the law. The courts interpret the laws and see that they are obeyed. In England, an Act of Parliament is a supreme source of law, not a judicial decision. In the case of A and others, and Secretary of State for the Home Department in 2004, after the House of Lords declared that the detention of 9 foreign prisoners in Belmarsh without trial conflicted with Section 4 of the Human Rights Act 1998, the Parliament decided to replace Part 4 of Anti-Terrorism, Crime and Security Act 2001 with the Prevention of Terrorism Act 2001. This act allows anyone of any nationality to be subjected to a control order, which is an order made by the Home Secretary of the United Kingdom to restrict an individual's liberty for the purpose of protecting members of the public from risk of terrorism. The case of A and others and Secretary of State for the Home Department 2004 showed that the Parliament has absolute supremacy when it comes to making and changing laws, and that valid acts of Parliament cannot be questioned by the court. The doctrine of parliamentary supremacy in making laws was further demonstrated in the War Damage Act 1965, an act that exempts the United Kingdom Crown for liability in respect of damage to or destruction of property caused by acts lawfully done by the Crown during a war. This is an example of British legislation that retroactively changed the legal consequence or status of an action that was committed before the enactment of the law, also called ex post facto law in Latin. This act was brought forward due to the case of Burma Oil Company Limited and Lord Advocate 1965. Involving the destruction of oil fields in Burma belonging to the claimant by British forces during the Japanese invasion of Burma in 1942. To summarize how the legislature and executive powers of the United Kingdom interact when it comes to judge-made laws, Lord Bingham of the case of Crown Jackson against Attorney General in 2005 stated that the bedrock of the British Constitution is the supremacy of the Crown in Parliament. Now, my colleague Yixin Jie will explain how the judiciary power of the United Kingdom functions, tackling the question of why judges make law and how they can take accountability.
Hi, my name is Yixin Jie, and we will talk about the judiciary. It's a branch of the government that interprets and then enforces the law. The highest court of appeal is the Supreme Court, and it governs the 3 main courts of England, Wales, and Northern Ireland, and it is the main court that handles constitutional issues. The hierarchy of courts in the UK, which starts from the Magistrates' Court, and then the Crown Court, then goes to the High Court, the Court of Appeal, and lastly the Supreme Court and the Privy Council. 3 main roles of the judiciary system, whereby the judiciary works alongside with the executive and the legislative branches to uphold the law. It also ensures that the law are properly enforced, whereby they will interpret it before enforcing the law. And lastly, the judicial review, which allows judges to review a decision or action made by a public body. Private bodies are inclusive of government and local authorities. They can overturn the decision of where it was made illegally, proper procedure isn't followed, and it was made irrationally. The court cannot overturn primary legislation, but they can overturn secondary legislation. Some examples that may fall under judiciary review may include education for special needs, authorities for immigrants, so the decision on prisoners' rights. In the case of R versus Chater and others, the members of parliament were involved in a scandal of criminal offences that they argued that they are protected by parliamentary privilege, that it's not within the jurisdiction of the criminal courts to charge them. Here in this case, both the Court of Appeal and the Supreme Court has unanimously dismissed the appellant's argument. They found that there's no notion in the basis of law that members of the parliament are protected by parliamentary privilege if committed in a criminal offense. The judgment stated that the fact that the court have fully supported in the police investigation gave no rights to the member of parliament, that they are protected by the privilege. The significance in judicial review in this case shows that how far are courts willing to extend the protection of parliamentary privilege for any members of the parliament or any future conduct performed by the members of parliament. Case of R versus Attorney General, the law concern was whether that conversations between a member of the royal family and the government ministers were disclosable under the Freedom of Information Act 2000, or were they exempted under Section 37, 40, and 41. Upper tribunal stated that there were reasonable grounds for the refusal of disclosure of these information. However, in 2014, the Supreme Court did a judicial review. They did not have the right to veto the disclosure of the letters and therefore reverted the decision of the upper tribunals, and the letters were subsequently disclosed. The significance and constitutional reform in this case shows that it is made clear that if senior members of the royal family are not protected from the disclosure under the Freedom of Information Act 2000, if the information are reasonably related to public interest. It is definitely an international concern on the accountability and certainty of judge-made law. Firstly, judges are appointed into the judiciary and carefully selected through a screening. To further support the accountability of judges, there are also constitutional limitations on judges, where the most important one would be the provisions for removal of judges if on the grounds proved of misbehavior and incapability provided in the Constitution of India, Article 124, subsection 2 and subsection 4. Constitution of the Judges Act 1968, Article 124, subsection 5. It's enacted to regulate for procedure for investigation and proof of misbehavior or incapability of judges in the Supreme Court and the High Court. If a judge has misbehaved or has shown incapability, removal will be necessary, so this ensures the certainty of the judge-made laws.
Hi, my name is Chong Fong, and I'll talk about the development of common law. The common law system has evolved over several centuries. Historically, customs and decisions of judges are main sources of law in the English legal systems. Customs are rules of behavior which develop in a community without being deliberately invented. So the two main types of customs are general customs and local customs. So what's the difference? General customs are the basis of the UK common law. Following the Norman conquest, judges are appointed by the king to travel around the land to make decisions on common customs on behalf of the king. Lord Justice Coke in the 17th century described these customs as being one of the main triangles of the laws of England. Local customs, on the other hand, are customs that are an exception to the general law of the land and will operate only in that particular area. Hence, judges from the earliest times established a series of tests that had to be passed before they recognized any local customs. The examples of the tests are: First, the custom must have existed since time immemorial. Second, the custom must have been exercised peaceably, openly, and as of right. The custom must be definite as to locality, nature, and scope. And lastly, the custom must be reasonable. These tests still exist today, but only be used in rare occasions that a claim to a right comes before the courts because of a local custom. Although customs may develop, they are not part of the law until recognized by the courts. There are two examples of the cases. The first cases will be the case of Egerton against Harding. The judge had been entitled to conclude that there had been an immemorial usage, whereby the plaintiff had been under a duty to fence, and that the duty had a lawful origin. Another example would be the case of New Windsor Corporation against Mellor, where the right in the inhabitants of New Windsor to indulge in lawful sports and pastimes on the land had been enjoyed for over 300 years. Hence, it had been established as a customary right. However, the legal system in England and Wales could not rely only on customs. During the Norman Conquest, in the year of 1066, the first Norman king, also known as William the Conqueror, set up the King's Court and appointed his own judges. This was because the Norman kings realized that control of the country would be easier if they controlled the legal system. Nobles who had a dispute were encouraged to apply to have the king or his judges to resolve their matters. As well as this central court, which is also the King's Court that I mentioned earlier, judges would travel from London all around the country that was under the control of the king to major towns to resolve disputes. During the time of Henry II, these tours become more frequent and countries are divided into circuits. Circuits, also known as areas, for the judges to visit. Judges then will return back to Westminster in London and discuss the laws or custom they had used and the decisions that had made with each other. Gradually, the judges selected the best customs or will then be used by all the judges throughout the whole country. Therefore, the law became uniform or also common through the whole country.
Interpretation of law by judges extends insofar there is documentation, such as a statute, to interpret. This does not apply to the vast majority of civil law cases in England and Wales. In fact, tort law and contract law, civil areas of law, are entirely judge-made law. The tests to ascertain the validity of contracts or determining tortious behavior are entirely formed by the judiciary. It is not the interpretation of statutes that led to the good neighbor principle in Donoghue and Stevenson. It is not the interpretation of statutes that led to the establishment of the 5 characteristics of a contract or the postal rule. These are legal doctrines that have been entirely formulated by judges. Likewise, in the modern day, we see more judicial interpretation of laws rather than the making of it. Constitutional law and criminal law is almost entirely governed by statute and documentation, and it is only up to the courts to decide whether or not the material facts of cases conform to the situations laid out in such articles of law. So why is judge-made law, common law, a thing? Following William of Normandy's conquest in 1066, many customs of England were observed by his judges, the magistrates. Initially, judges relied on local customs when judging cases, and did so when traveling to many different parts of the kingdom. However, as time went on, the judges got together in Westminster and deliberated on what they believed would be the most fitting customs of the land, and chose to standardize those rulings for all other judges to follow. The purpose of such a practice was to give law a reliable and consistent character across the land, regardless of local customs. Stare decisis, a Latin phrase meaning let the decision stand, is a mechanism through which this principle applies. Prior to statutes, stare decisis helped cement the idea that like cases ought to be treated alike. If not for such a doctrine, justice would be an alien concept, as there would be no universal marker of justice for all to follow. Coming back to contrasting areas of law, we can see that the development of criminal law and constitutional law arose from statute far later than the developments of common law. This reflects the demands and expectations of a Western European country entering liberal modernity. Concepts such as the rule of law and limited government were emphasized far more when the reign of monarchs was no longer absolute, and the populace began to have a say in governance. While not applicable anymore, the highest application of this principle, that the sources of law in England evolved as the world around her evolved, is that of EU law. a truly novel institution and concept that would have been unimaginable in 11th century England. Thusly, we see that judge-made law played a pivotal and frankly sole role in determining law in England and Wales in the past. But now, statute law and the role of Westminster in legislating law has become more commonplace, especially if liberal values have come to govern the United Kingdom and the belief that the laws should reflect the will of the people rather than that of an unelected academic elite judicial class.
While statutes and acts play a pivotal role in lawmaking, I will now be covering the legal doctrines which make judge-made laws possible, commonly known as the concept of specifically stare decisis, which gives rise to common law. As was illustrated by B before me, stare decisis was born out of the customs of locals. Stare decisis. What is this? This is a Latin phrase which translates to let the decision stand. The concept of stare decisis was explained by Chancellor Kent as such. Any solemn decision finalized by the court of law must become an authority in similar cases, as is the highest level of evidence present applicable to the subject. Such a precedent will be called an original precedent, which is formed via the reasoning of analogy among many judges, as they use their judicious minds to reach an outcome. This will then be binding on all the lower courts. The main reason behind its prevalence is to preserve continuity and certainty in the law, as well as predictability in relation to the outcome in certain cases. In short, all similar cases should be treated alike. Now, moving on to case law. In the case of Castle versus Broom, the House of Law established that any decisions made by the higher courts must be abided by all lower tier courts. It was at this point historically where the traces of the idea regarding the doctrine of judicial precedent can be found. The doctrine suggests that courts must honor the previous rulings brought about in previous cases. However, within the aforementioned doctrine, it is not an absolute must for courts to adhere to the prior judgments. The following considerations are important to address. So when looking at precedents, there are three parts to them. Part 1, orbita dicta. These are the non-binding comments made by judges in court decisions. Number 2, orbita ratio. This is a statement of law that is not essential to the decision, however, still binding on lower courts. And finally, ratio dissenting. This is the legal principle or rule of law that is binding on lower courts and future cases that have similar facts. Moving on, when it comes to the types of precedents, there are two types, vertical and horizontal. Starting with the horizontal precedents, what are these? These refer to the extent to which a court at the same level is bound to follow earlier decisions. An example being, if a court of appeal adhered to the ruling of a previous court of appeal case, then this can be said to be a horizontal stare decisis. Now, when looking at a vertical precedent, this refers to the extent to which a court lower down the hierarchy is bound to follow a decision of a court higher up the hierarchy. The Supreme Court bound to every court, but no court can be bound by a lower court. So when the court faces any legal argument, if a previous court has ruled on the same or closely related issues, then a court will make their decision in alignment with the previous court's decision. The previous deciding court must then have binding authority over the court. Otherwise, the previous decision can be said to be merely persuasive.
Greetings, my name is Teo Ginger, and I will be presenting to you today the advantages and disadvantages of judge-made law. I'll be drawing comparisons to legislative law with judge-made law to create a better and clearer understanding of what both sides have to offer. Judge-made law, in essence, is case law or stare decisis that enables judges to be able to judge cases according to the individual facts and details of those cases. This gives us our key advantage, which is flexibility. Precedent and case law can always be tweaked by judges, providing the platform for assurance that each case will be decided fairly. The judges will interpret each case according to their own individual facts and details to provide the best outcome for both parties. This sort of adaptation is greatly appreciated in the ever-changing nature of society today. Coherency and predictability is another advantage when it comes to judge-made law. as the lower courts are bound by the higher courts, creating a system of precedent in the legal system of the UK and Malaysia. This ensures that there is no wild or absurd result resulting from the courts. The parties always have a guarantee that there is an extent of predictability and congruency in the result given by the judges, as again, promoting fairness in law. Ultimately, judge-made law revolves around the judges themselves, highlighting their expertise and their important role in the courts. Judge-made law provides us the advantage of specialist knowledge, as judges may have more knowledge towards specific areas of law that they have garnered through years of experience and work. Compared to legislative law, the judges' knowledge, combined with the flexible nature of lawmaking, enables them to better interpret the situation of different cases. On the other hand, it must be noted that although flexible, it is not always consistent. Judges are also human beings. They may have different opinions and different beliefs towards different situations, different interpretations, and different cases. That being said, judge-made law always has the possibility of inconsistency or unprecedented decisions being made in the eyes of the parties, as judges may have to follow precedent, but at the same time, they may also want to tweak judicial interpretations according to their own beliefs or their own opinions. This may sometimes cause confusion between the parties as well as undermine legal certainty. Some may argue that since judge-made law is not fully dependent on legislative law, there is a lack of accountability and recognition in terms of governments and statutes. Judges, by profession, have the power to shape law and provide judgments according to their own interpretations. But we must keep in mind that these judges are not elected officials of the government system, so their opinions are not fully representative of those of society. And again, this power that judges have may be overused to the extent that it crosses the boundaries between the branch of the judiciary and the branch of the legislative in the system. So this may lead to new laws and precedents being created according to the judges' own beliefs and their own opinions. This would topple the balance and create systematic and internal problems within the system.